Number 75, Sage Systems versus Liss. Counsel?
Your Honors, Christopher Raimondi of Raimondi Law PC for the appellant. I'd like to reserve 2 minutes of time for rebuttal.
2 minutes? Yes.
Thank you, Your Honor.
You may proceed.
Thank you, Your Honor. Your Honors, in this case, the partnership agreement at issue does not provide for attorney's fees in direct actions. That is abundantly clear. The Court of Appeals has made it repeatedly clear that where an indemnification provision is not unmistakably clear in providing for indemnification of attorney's fees in direct actions, the recovery of such fees are not permitted.
Counsel, is your argument primarily that it had to say the words attorney's fees, or rather that it had to say that you get recovery in direct actions?
Well, it's two parts. I mean, one, it doesn't mention attorney's fees at all, Your Honor, nor does it even mention a duty to defend. So there's no mention of attorney's fees whatsoever.
And is that determinative in your view?
No, it is not solely determinative. The second part of it is that it is of such wide-reaching language that it doesn't in any way specify that it applies to direct actions. And that is something that this court has required in Hooper Associates versus AGS Computers, most recently in Ambach Assurance Corporation versus Countywide Home Loans. And I believe that three of the justices here today were actually present on the bench when that decision was rendered in 2018, where the court took a look at Hooper and said, no, we got this right, and this is what should be followed. There must be, in fact, in Ambach, it said it must be an unmistakable promise to cover the attorney's fees in a direct action. Hooper said that the intent must be unmistakably clear. In fact, the appellate division, First Department in Gotham Partners, looking at Hooper and applying it, went so far as to say that the intention must be virtually inescapable.
And you're saying there's a different standard if it's direct actions versus third party?
Well,
Or
only
the same standard? Where are you on that?
So the standard is that, yes, it's that Hooper applies here, and so does Ambach, and that the issue here is that there is no language. 1302B can be read to cover third-party claims without question. It would be a stretch to have it cover direct actions. But
So I'm sorry, it could be read to cover attorney's fees in third-party actions. So so let's say, that's a little confusing question, sorry, but let's say we have this clause, and it's between the two of us. You get sued by a third party based on my actions. You lose, or you win defending it. You now come after me for indemnification, right?
That's a third-party action, yes, Your
That's the
Honor.
third-party action.
Correct.
So that would that be enough, the language that you have in here, to allow you to recover from me for attorney's fees?
It is not clear from this language that attorney's fees are even covered, but the best argument would be in the context of a third-party action that there may be coverage for it.
But didn't we say in Breed that this language did provide coverage for?
Well, that Breed's a different situation, Your Honor. Okay, in Breed, the agreement at issue was not a partnership agreement as we have here. This was an escrow agreement where a law
No,
firm...
I understand the difference in the contracts, but the language in Breed was pretty much exactly the same as what you have here.
No, the difference here, Your Honors, is that this court was unable to conceive of any way possible that that language could apply to a third-party action, given the nature of the contract.
But it didn't say attorney's fees in that language.
It did not say attorney's fees in that action, but the issue was, what other damages would there be to an escrow agent, an attorney acting as an escrow agent, in the event that something went wrong? It would be that they would be sued and have to defend against those
I
claims.
thought it was more that in what other context would this apply than in direct action?
Well, correct. It is that, and that's because it was an escrow agreement. If this were not an escrow agreement, it's not clear to me that the same decision would occur.
Okay,
So as a baseline rule, if the conclusion that it covers attorney's fees is inescapable in the context of the agreement, the fact that it doesn't say attorney's fees could still permit such a recovery.
In the narrow application of Breed Abbott, I agree, based upon the type of agreement that it is. This is not that type of agreement.
Okay, so I need to get back to my question, because
Yes, Your Honor.
perhaps you were trying to answer it, but I didn't understand the answer. Is there a different standard that applies if it's a direct action versus a third-party action.
Is there a different standard? I don't.
Yes, a standard to determine whether or not broad language, like what we have here, like what existed in Breed, encompasses attorney's fees.
Well, the issue is the
Or
language.
is it always the same standard? The standard?
It is always in my understanding,
Yes.
from the decisions of this
Yes.
court, Ambach and Hooper,
Yes.
is that it must be unmistakably clear. There must be an unmistakable promise that one party is going to cover another party's attorney's fees in a direct action. And if it does not do so, then such a recovery of attorney's
Okay,
fees
so my
is not
okay,
possible.
I get that. Okay, so my question is, does that mean it's a different standard if it's a third-party action? That's the question I'm trying to get you to answer.
No, I think the answer is this. With the third-party action, I don't think that there's a question that it covers third-party actions. I think that the language does cover third-party actions. Broad language, this court has found, does cover third-party actions, and in fact,
Third-party actions to recover attorney's fees.
Correct. Damages, attorney's fees, yes. That is correct.
So you're saying then it is a different standard
No,
for
it-
direct action?
the-
It's
the-
a straightforward question.
I
Is it the
don't believe it's a
exact
different
same
standard.
standard?
I believe the Ambach and Hooper standards are the standards that should be applied, which is based upon the language.
Regardless if it's direct or a third-party action? Is that your point?
Correct. Well, that's how yes, that's how the determination is made. Yes, through that standard.
But, so I guess that I come back to, this provision is an indemnification provision, right? So it clearly applies if, in my hypothetical, you get sued by a third party, you have to defend based on my misconduct, right?
Okay, Your Honor, this particular provision actually has a threshold question of bad faith before we get to that, but let's assume that for the moment and the
Good
purpose of your
point.
question.
Let's assume it.
Okay, so assuming that,
So, in that case, you turn around to me, you win, but you spend money defending the action, and I've committed something that got you sued, my conduct. You turn around and you want to recover your fees, expenses, et cetera, under this indemnification provision, yes or no?
I think under this indemnification provision, the question of attorney's fees is up for debate, and I don't believe that it would be recoverable in that context.
Because it doesn't say attorney's fees, or why?
Because it doesn't say attorney's fees, it also does not reference a duty to defend. There is nothing to indicate that these expenses or fees would cover attorney's fees.
So would one or the other be sufficient?
Something to indicate that the parties, personally, based upon this court's rulings, it should be an unmistakable promise or clear, unequivocal
Well,
language.
I thought we were
that
talking
it was
about a
intended.
third-party action now, not about an action between...
For either, it should really be clear what the parties intended. There's nothing wrong with having a clear contract.
Let's say this said attorney's fees, right? And now, it says attorney's fees, same hypothetical you've just been using. Now you turn around and you want indemnification from me. Let's say, different case, says attorney's fees. Same provision, but it has attorney's fees in it. Now you sue me directly for something under the partnership agreement, right? I've done something wrong. And you win. Do you get attorney's fees? Or does it have to say it's a direct direct
Yeah,
action?
right, exactly. It does not say direct action. There's nothing to indicate direct action. So in
Even
that-
if it had the specific language, you'd still need something to indicate it applies in direct actions.
Yes, Your Honor, I see my time expired. May I
okay.
answer?
Yes.
Thank you. So the answer is this. With respect to third-party actions, if the word attorney's fees was in this provision, they'd be entitled to attorney's fees for third-party actions. With respect to direct actions, as there's no language showing any intent, and certainly not clear intent, of the parties to be bound to each other to pay for attorney's fees in a direct action, attorney's fees are not recoverable.
Another way to say that, though, would be if we agree with you on direct action, we don't have to get to the language issue.
Correct. Well, you have to use the language to get to direct action. You have to look at the language of the agreement in order to
But
determine.
if we say it doesn't apply to direct action, who cares what it says?
Well, Your Honor, it's not what I said. The motion court itself said the provision contains no reference to direct claims between the parties. That's record at page 10. That was in the decision of the motion court. The motion court found it didn't apply to direct actions.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, my name is Fred Seaman, and I represent the respondent in this action, and the plaintiff in the original action, Sage Systems. I believe that if we go back to the underlying action, there is every justification for the trigger of this indemnification clause. Otherwise, you're going...
What is the unmistakably clear language that requires attorney's fees?
In Section B of the agreement, shall be indemnified and held harmless by each partner from any and all claims and causes of action of any nature whatsoever arising out of or incidental to any act performed by a partner, which is not performed in good faith, not reasonably believed to be by such partner to be in the best interests of the partnership, and, I'm just skipping a little, and is not reasonably believed by such partner to be in the best...
That doesn't go to the recovery, which is, I believe, what Judge Troutman is asking about. Where's the part that says you can recover attorney's fees, given everything else?
Okay, again, I would go back to the original action. That was really...
No, in this provision.
It doesn't say that, it doesn't say that specifically. If you're going to parse the language...
Wouldn't be here if it said it specifically. So here's the question.
Exactly, right.
Where can one infer or somehow conclude from this language that it includes attorney's fees? Or is there some precedent of ours that you would say, that
I would-
tells you that this
I would
language
go to the
equates
language-
with attorney's fees?
Your Honor, I'd go to the language of Breed. Breed says, if not here, when then? If it doesn't have attorney's fees.
But counsel, to that question, the language you just read could include attorney's fees, but it could include many other items of indemnification. So my question is, what makes it inescapably, pardon me, concludable that it was meant to include attorney's fees as well?
I would go, again, I would refer this court to the language of Breed, where the court used a common
What
sense...
about the argument that Breed was applied to those unique facts only?
I think we have those unique facts here, Judge. You have what I would amount to a judicial mugging by one partner of another. What we're really saying is the motion court, Justice James, was unbelievably kind and polite. And in a sense, I'm here...
No, but the unique facts that I think that question that Judge Troutman is asking is related to is not the nature of the trigger, right, the bad conduct. It is the whole point of the provision,
That is
right?
correct.
And
I agree with that.
Breed, the court is actually looking beyond the language and saying the only point to this clause is to ensure that legal expenses are covered, which includes attorney's fees.
And I would conclude, as did the appellate division and the motion court, that that's the same reasoning that ought to apply here.
But that's
you ought
based on the
not-
relationship there, because it's an escrow account, and it's an escrow
And the
which is
relationship-
not, these are partners.
Understood, Your Honor. And the relationship here is a partner. One partner attacks another partner to dissolve the partnership. So in the language of this particular indemnification, it's certainly not in the best interests of the
Well,
corporation.
I'm not going to debate with you that it might very well fall within a category of conduct that allows for an action. The question is, are attorney's fees recoverable? Maybe you can get the cost, damages, expenses. So the question is, why don't I see the words attorney's fees, or even the word fee?
We ought not, I respectfully submit, we ought not, as a court, to require practitioners to parse the words in such detail that
Well,
here...
if the court says you got to include the words attorney's fees, wouldn't that make it easy? Everybody moving forward knows, always include them. You won't have an appealable issue.
I respectfully submit that that would not be particularly good
So
policy,
you
because now...
didn't, you didn't in your papers address AMBAC. Would you like to address it? I mean, AMBAC, the language in the contract in AMBAC actually says attorney's fees, and we nevertheless said they were not recoverable.
Right.
So this is your chance to say something about AMBAC if you'd like.
I don't, we didn't address it in the papers. We don't think that it is persuasive here, that we think that we rely upon Breed as, the language in AMBAC was a traditional indemnification, but it was,
That included attorney's fees expressly.
yes, it did. But in that instance, the relationship was different. it was between two very independent parties. Here you have two partners, so I fall back to the relationship of the facts, meaning you have two partners, and you have an attack on the very partnership itself, a very different situation than exists in AMBAC.
Counselor?
Yes.
You keep commenting on Breed, but didn't Breed stand for the proposition that if there was no other cost other than attorney fees, then we could rely on that for attorney's fees? Is your contention here that there are no other costs that would be covered?
That is exactly correct, Judge. Thank you. This is an instance where how have we been damaged? By a completely false accusation, a completely baseless complaint. How else have we been damaged but for forcing us to defend ourselves and pay for attorney's fees? So yes, that is the proposition that I set forth before your honors.
Can I ask, I'm sorry if you've answered it, it's the same question I was asking to your adversary. Is it your view that it's the same or a different standard that applies to direct action versus a third-party action?
I believe it's the same standards, that if one partner committed a fraud and forced a third party to sue the partnership.
No, I mean in terms of interpreting the provision, interpreting this provision.
I
Is it the
thought I
Hooper
understood that.
standard?
Yes, I'm sorry?
Is it the Hooper standard?
No, it's not going to be the Hooper standard. It's going to be, that's difficult. Yes, I would say yes because, depending on the facts. Here, I believe that the facts as before you are very close to Breed. I think you'd have to.
Well, your provision is exactly the same almost as Breed, right? It doesn't say attorney's fees, and neither did the provision in Breed, whereas the provision in AMBAC said attorney's fees. So it seems the one rule we could gather from those cases is whether or not in a direct action versus a third-party action, the inclusion specifically of the magic words attorney's fees isn't determinative, right?
I agree with that. I think that your honors are going to have to look, and the court's going to have to look at the set of facts in each instance.
Yeah, but so if it's not determinative, what are the factors or considerations for a court to look at? If the words themselves are not good enough.
Where it's unequivocally referable, where you look at the facts, you look at the language, there's no other conclusion that you can draw. And I would, again, respectfully submit that that's what happened here. You can't.
But I guess the question to me then would be, what's inescapable? Is it attorney's fees were included, or that the indemnification provision provides to direct actions between these parties?
That the indemnification provides for the direct action between the parties, and it is meant to deter the kind of conduct that occurred here. That's why that provision was in that, to prevent the filing of baseless claims against one partner by another to destroy that partnership. And I know your honors, or at least I'm getting a sense, it's obviously in retrospect, it would have been nice if it said attorney's fees, and you're correct. But I don't think that should be the hard and fast rule. I believe that you do have the kind of facts.
Why not? Why not have that rule? There's obviously some
Because you're going to
confusion.
hurt, I think it goes against.
Let me say this, if it didn't say damages, do you think damages are covered?
Yes. No, if it didn't say
It
damages,
didn't have the word damages, could you recover damages?
no. It has to say damages, otherwise,
So if it
that's
doesn't
the
say
broadest
attorney's
of all.
fees, why should attorney's fees be covered?
Because attorney's fees are a subset of damages. In this instance, the only damage we suffered was attorney's fees. That's why it's recoverable here with this clause. And I think it'd be wrong.
Did you make that argument below, that fees are actually subsumed by the word damages?
No, we did not. I did not. I argued that now because those
You
are.
agree that there, of course, are many lawyers who, in their string site of what's recoverable, do include attorney's fees as a separate category from damages.
I do, Your Honor, and I'm not standing here advocating that, we ought to be loose and fast. I'm just
And there are
saying,
statutes that expressly allow for recovery of attorney's fees, even though otherwise damages would be recovered.
that's correct.
Right? Legislators have
understand
found it
that.
necessary to say that because we have a thing called the American rule, right?
I agree with you, but I think to slavishly follow that rule here would be a disservice. And I think that's why we need to, that's why I respectfully submit that the decisions below ought to be affirmed. Thank you, Your Honors.
Counsel, can you address the question that I asked? What other types of disputes do you think this indemnification provision could cover?
I think that I think that what it's designed to cover primarily is third-party disputes, where a partner behaves in a manner that is outside or a recent detour that creates liability for the partnership and/or the partners. That's what it's designed to prevent. I don't think it's designed to prevent direct action between the partners. It makes no mention of that. It seems to be very well focused on an act that would be ultra-virus, inappropriate. It talks about fraud. It talks about a partner going off and doing something that creates liability for the partnership and its
So
partners.
is it your position that none of these items that can be indemnified under this agreement would be indemnified in a direct action?
Yes, because it doesn't apply to direct actions, correct.
And would one way to look at that be, as I'm thinking about it, the fact that it doesn't include attorney's fees, one indication that it doesn't apply to direct actions? Not the sole indication, but one indication.
It's not even requiring, as I had said before, it's not even requiring a duty to defend. Nothing related to attorney's fees or defensive action in any way is referenced at all in this provision.
But I guess my point is, in terms of indemnification, when you're coming to try to recover something from me for having to defend against this third-party action, indemnification covers a number of different things subsumed in this type of breed language. If it was intended to apply to direct actions, the American rule would kick in, and you'd want to specifically mention attorney's fees in there.
Well, correct. I mean, look, the right way to do this, Your Honors, I think would be a prevailing party provision that directly addresses this. That separate provision, as what was found in other cases where there is language that is clear that applies to direct actions and other language that the more broader language is applied to third-party actions, is the correct way to go. I think the best practice here is a separate prevailing party clause related to direct actions. Just to address something else with respect to the damages that Mr. Seaman was arguing about, with respect to the unclean hands argument that was made here, and we believe that the finding is incorrect because it doesn't meet the three-part test of this, the third branch of which is that the party was injured by the conduct. Well, in ABAC, this court specifically said attorney's fees are treated as incidents of litigation rather than damages, except where an award is authorized by agreement between the parties, or by statute, or by court rule. Well, none of that exists here. So the damages can't make the basis of unclean hands. If there isn't unclean hands, there wasn't a proper finding by the dissolution court, then 1302, we respectfully submit, does not apply at all, and therefore, there's no reason to even get to that part of it.
Thank you, counsel.
Thank you, Your Honors.